Seth, hang on. Case D 506478, you're Cassandra Gutierrez?
Yes.
Seth Gutierrez? Okay, Counselor, you want to make your appearance?
This is Seth Gutierrez, bar number 12974, Your Honor.
Representing improper person, so I need to swear both parties in?
Thank you, Your Honor. I did have a
Would you
question.
both please raise your right hand?
Let's swear you in first before we take any testimony.
You and each of you do solemnly swear the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth, so help you God.
It is.
Thank you.
Okay,
Please be seated.
Mr. Gutierrez, you have a matter, procedural matter?
I just wanted to inquire as to the identification of parties not known to the defense within the courtroom.
Who did you bring in court with you today?
Just a
A friend? And you're asking for a closed hearing?
I am, Your Honor.
Okay, unless they're a family member, then the matter would be a closed hearing at the request of one of the parties. So Martin, is a closed hearing,
Are you a family
not a family member?
Okay, stand up, stand up, stand up.
Yes. All right, closed hearing rule invoked, and parties are sworn in. You may be seated. Cassandra, you have a motion for summary judgment. Is that correct?
Yes, Your Honor.
Okay, do you want to summarize your motion for me?
Your Honor, I feel like I was under duress and I felt coerced to accept the paperwork that he gave me when I got no paperwork prior to that. So I feel like I didn't get due process of law, so then I filed a motion to dismiss everything.
Which paperwork? Oh, okay, is that the
Yes.
one where the court told Seth to do a proposed order to show cause and a detailed
Yes.
affidavit?
Yes.
And
Your
you're
Honor.
arguing that he did not file or submit to the court the proposed,
Yes.
and without that, then there's nothing to litigate,
That's
correct?
correct, Your Honor.
All right,
I
is
didn't-
there, I think your other reasons are that if we look at all these orders, did these orders supersede, the later orders supersede the prior orders? Two parts to that, correct?
That's correct, Your Honor.
Is there any third reason or fourth reason?
I just feel like I wasn't served properly beforehand. I didn't have any paperwork to be able to defend myself or to know what I was being charged with or anything.
Okay, I think I understand, so I'm gonna have Seth respond to that.
Your Honor,
Have you submitted a proposed order to show cause?
no, Your Honor.
And why is it you haven't submitted the proposed order to show cause?
Your Honor, it's my understanding we're holding everything in abeyance until January. If you need that order, I can file it today with the courts.
Question, did the
However,
court submit a deadline for you to submit the order to show cause? We did start day one of the trial on July 24th. I said I'd hold it in abeyance for 6 months, see how everything is doing, but your order to show cause, it says here you should submit a detailed order to show cause, but there was no deadline to do that. If there was no deadline, it would be before the next court date.
Right, Your Honor.
So
And-
you
and-
intend to submit an order to show cause?
I do, Your Honor. I'll have that before the court this week.
If the court says that you can submit the detailed order for show cause, then we have to deal with the applications of any prior orders. I guess you both know the case much more closely, obviously, in terms of these orders, because there were orders on July 31st, 2017, and do you remember what the other order? There was a March 19th, 2015 divorce decree, correct?
Your Honor, the orders that the plaintiff is referencing in here, the first order, if I recall correctly, is
Well, the very, very first
divorce
order is the
decree.
divorce decree.
right. And what I would point out is that in addition to the divorce decree, she points to the stipulated parenting agreement that was to act as a supplement when this court ordered us to file a more detailed and more specific, with more detailed language of the parenting agreement, but in no way superseded the actual divorce decree itself. Likewise, with future orders, there's been no order by this court that any specific order supersedes a prior order.
The court had made a directive to do more specific joint legal custody provisions. Was that done?
It was, Your Honor, and that order, that stipulated,
Is the July 31st
I believe so.
modifying
Yes.
the parenting agreement?
That is correct, July 31st, 2017.
Okay, so Mom, how does that come into play? If these things were modified for more detailed, I guess Dad is arguing that it is more detailed, and so it adds on to the order. What provisions are you saying superseded any orders?
If you get a new order, I don't understand how the old order is no longer.
Depends on the provisions. If a new order comes, then if there's anything that supersedes, yeah, it'll supersede. But if it's anything in addition to, it's an added provision. I understand your position in terms of the motion for summary judgment. Counsel, are you arguing pursuant to NRCP 56, the new rule, that any motions for summary judgment should be filed within 30 days from the close of discovery?
I am in paragraph A of my points and authorities.
Are these the new rules that went into effect, or
Is my understanding.
what's the subsection?
It is subsection B.
Or has that been modified by the change in the rules?
I'm not aware of any modifications.
Subsection B, well, that's for defending party. I'm not aware of the 30-day rule. Can you point that out to me? Summary judgments are typically filed at any time before the, I guess, a hearing or a trial. She filed this motion while we're in the middle of a pending trial.
And she's filing it reference to the hearing that.
If
occurred
I
on-
say that, well, typically people don't file motions for summary judgment in the middle of a trial. Normally they'd file any motions for directed verdict, but the close of evidence hasn't occurred yet.
And
So it's like a fugitive motion.
And so even if this court doesn't find that she's procedurally barred from filing this
Right.
motion as a matter of law,
Yeah.
I argued in paragraph B
Okay.
that there is no actual order that's.
We have to follow the court rules, Cassandra. What we do, we are in the middle, we're awaiting day 2 of trial. We are in the middle of the trial. So number 1, the courts do not hear motions for summary judgment in the middle of a trial. Number 2, if you wish to file any motions for directed verdict, then you have to wait. It's untimely. It's not a motion today. You have to do it at the close of evidence. Number 3, in terms of any superseding of orders, I suppose that can be deferred to if she files a motion for a directed verdict. Number 4, the court didn't set any specific deadline for Seth to file the order to show cause. I will set a deadline now since you filed this motion today, even though the motion is kind of a fugitive motion. So I'm going to deny your motion for summary judgment as it is improper to file it in the middle of a trial. Number 2, if you want to file a motion for directed verdict, you have to wait until the close of evidence. Number 3, I'll set a deadline for Seth to file that order to show cause, the proposed order to show cause, and referencing the orders. That way you can prepare your case for the next day of trial. However, all I have set is a January 20th status check to see how things were going. You did complete, I do make a finding today as part of this trial that she completed the UNLV co-parenting plan. Is that correct? You filed the completion?
Yes, I did, and I completed the
Okay.
other 2 as well.
My list also says you were supposed to do the COPE
I
class.
have them right here.
Do you have extra copies?
These are the extra copies. I have the
Okay, so
originals.
you can give one to Dad, and I'll look at the extra copy. Have you filed that COPE class, children in the middle? Have you filed that, or you want to submit one to the court for filing? We can take this.
You can.
Yes, so this is the stepping stones, triple P, the
That's
court.
correct.
So finding number 1, she did the UNLV COPAD class, high conflict class. Finding number 2, she did the stepping stones, triple P, and we'll put a cover sheet on that and say completion of stepping stones. Finding number 3, she did the courts COPE class, and we'll put a cover sheet and say that she complied with that. Did Dad have anything to do on his end? No, nothing. Alright, so she's in compliance with all of those 3 classes. And we have our January 29th at 10:30 a.m. to see where we go from there.
Your Honor?
Yes.
May I speak?
Yes.
Since I have charges against me, I would like a free attorney because I can't represent myself, and what's happening right now, I don't understand. And, I feel like I'm being taken advantage of, so I would like, to be appointed,
Have
an
you
attorney.
applied with legal aid due
Yes,
to
I
your
have.
financial condition?
Yes, I have. Because I'm not domestic violence, they won't give me
Okay.
one.
I'll cite to the law. The law says that it's not it's not compulsory in a civil case. In a family court case, is a civil case. In criminal cases,
Even though I'm facing
they
jail
are.
time?
I'm sorry?
Even though I'm facing jail time?
I believe it's discretionary with the court in terms of that, but the court doesn't provide the legal aid. The legal aid provides the free attorney. We can't mandatory appoint, but if you wish to brief it and bring Seth back to court on that motion for a court-ordered pro bono attorney, or to have them pay your legal fees, you file another motion then for attorney's fees or appointment of an attorney, and you have to cite case law on that, and then he'll oppose it, I presume, and then we make a determination if you would get a court-appointed attorney. But they are not mandatory like they are in criminal cases. I believe it's discretionary to seek out attorney's fees or continuing the trial based on him if you do get an order that he pays your attorney's fees.
Okay.
And have you looked around for attorneys and they're asking for retainers?
Yes, I have.
Then
Yes,
you
I
have to set it all out in your motion, how many attorneys you shop for, what are going to be their retainers to complete a contempt trial, and then you're going to want time, I suppose, to presume, if you do get an order for attorney's fees, to save up that kind of money and collect it from Seth, or Seth will argue there is no basis for the appointment of a pro bono attorney. And you can continue to get on their list over at legal aid unless they've turned you down already.
They've turned me down.
Then you have to shop for a private attorney and then file a motion for attorney's fees, I presume, and then find out what their retainers are, and then cite to me any kind of law that says I am entitled to a pro bono attorney. Okay?
Okay.
All right, so the motion for summary judgment, it's a fugitive motion. I'm going to deny that with prejudice because that's in the middle of a trial, and no motions of that sort are entertained at trial. We do motions for directed verdict, etc. Okay. All right. So deadline. When would be a reasonable deadline? We were here in July. I figured you were going to just submit that. All right, 30 days to get that done. No, actually, we're coming back to court January 29th.
15.
I will give her at least a month to review the affidavit or order show cause, and we will approve that with scrutiny. Make sure you do a page number, line number, and it comports with the Awad case and the Cunningham case. Very detailed. It has to be very detailed. And then you have to personally serve it on Mom unless she accepts service of the show cause order and the application. Typically that has to be personally served because there's no lawyer on the other side. All right, I anticipate Mom will be filing a motion for attorney's fees or an appointment of an attorney. We'll brief that, and you guys have to present to me the case law on that. Okay? All right, I'll have Dad prepare the order from today. That's it for today.
All right.
Thank you.